In this short video, we're going to look at an evaluation essay on criminal law. This essay is on insanity and automatism. Evaluation essays appear on exam 3, and you'll have to answer one on criminal, one on tort, one on contract. This is a criminal essay on insanity and automatism. The question is, insanity and automatism are defences which should be both clear in their application and fair in their results. Too often, the opposite is the case. Discuss the extent to which this statement is accurate. As usual, that's worth 25 marks, and you would have 45 minutes to answer. Now, although this question looks a little bit daunting because you've got a quote and you're being asked to discuss whether it's accurate or not, really all it's asking you is whether the defences are clear and whether they lead to fair results. And my little image here of internal-external is just to remind you that the difference between the two defences is that insanity is by internal causes, automatism is by external causes. And that distinction isn't particularly clear, doesn't lead to particularly fair results, and that's really what this essay question is getting at. So if we scroll down to my suggested answer, I've done my AO1 in black font, my AO2 in red font, and I've highlighted the cases. You'll also notice that I've used subtitles in my essay. You shouldn't do that in the exam, but I've included them in my essay just so that you can follow the structure of my essay more easily. So if we look at my introduction then in this suggested answer, I've started off by saying that the defences of insanity and automatism have been heavily criticised by the Law Commission. Law Commission wrote a report on these two defences in 2013, and in that report, the Law Commission pointed out that the two defences overlap and that there is this artificial distinction between external causes, and that's proven particularly problematic. So straight away in my intro, I'm linking to the question. I'm then going to start by looking at the defence of insanity. Once I've done that, I will consider the defence of automatism. Better to do it that way than to muddle the two up. Firstly then, the defence of insanity. I've got my AO1 comments here. I'm saying that it's a general defence available to all crimes, and it's special because if you plead it successfully, there is a special verdict of not guilty by reason of insanity. Remember, in the past, that often led to lifetime institutionalisation, which years ago was particularly horrific in some instances, but that was preferable to facing the death penalty if you'd been charged with murder. I've put here that we still have mandatory detention if it's murder, but in other cases, detention's at the discretion of the judge. Some AO2 points here, these are evaluative or analytical points. I'm pointing out that the defence isn't as important as it used to be because we now don't have the death penalty. We also have diminished responsibility as a defence. That came from the Homicide Act, and it was amended by the Coroners and Justice Act. So we now have this defence, which can be relied on for a murder charge as well. And because of that, the defence of insanity has actually reduced in importance, perhaps. If you look at the data, there's only a very small number of successful pleas each year, typically under 30. So I'm setting the scene here about the defence, and then I'm going to get into the rules of how you plead insanity. So the defence is governed by the ancient case of Macnaghten, so that comes from 1843. Straight away, I can give an evaluative point here that the law is outdated. It's not kept up with advancements in psychology and medicine. Really strange that our law's still being governed by such an old case. Back in 1874, Lord Bramwell said, that the law lays down such a definition of madness that nobody is ever mad enough to be within it. And that's a really interesting point, of course, because before you study insanity, I think most people assume that it's going to be psychopaths, people with serious mental conditions. However, we've seen, of course, that it actually includes epileptics, diabetics, sleepwalkers. And so it's a really strange legal definition, not a medical one. So starting off with how it works then, the main rule is that every man is presumed sane until proven otherwise, and the defendant must prove that he is insane. I can criticise this because the fact that the burden of proof is on the defendant is at odds with the general principle that you're innocent until proven guilty. Also conflicts with Article 6 of the European Convention on Human Rights, that you're entitled to a fair trial. What should happen is you raise the defence of insanity. Prosecution should have to prove that you don't meet it. So I'm now looking at the first element for proving insanity. Firstly, we have to show that the defendant is suffering from a defect of reason. Short periods of absent-mindedness are not enough. You can use Clark there. Secondly, the defect must be caused by disease of the mind. Now, disease of the mind is rather confusing. It's misleading. This is a nice AO2 point, because although it says disease of the mind, it actually covers any physical disease which affects the mind. So in the case of Kemp, arteriosclerosis was held to be a disease of the mind, although that was a disease which actually affects the veins because the blood wasn't going to the brain quick enough. It affected the brain. It was a disease of the mind. In the case of Sullivan, epilepsy was a disease of the mind because that disease obviously affects the brain. Diabetes as well, a sort of physical condition, again, does affect the mind. So these all show that this disease of the mind element is misleading. Lots of people have criticised the defence, saying that it's rather absurd that some physical conditions such as epilepsy are going to be insanity, whereas some mental conditions, such as the irresistible impulses in Byrne, are not allowed. Final element of insanity is that the defect of reason was from a disease of the mind which caused the defendant not to know the nature or quality of his act, not know what he was doing was wrong. And that comes from Windle there. I'm now going on to consider automatism. Little introduction here that automatism is a full defence which leads to a complete acquittal. And the reason for that is because the defendant does not have the mens rea and is not acting voluntarily. You could put some criticism in here straight away that some people think that automatism shouldn't give rise to a complete acquittal because the defence is saying that the person's acting without thought. But if that's the case, then actually many everyday actions, such as driving the car, for instance, are carried out automatically without there being distinctive thinking processes involved. So this situation's not actually as exceptional as the defence suggests. I get on then to look at the requirements of automatism. In Bratty and the Attorney General for Northern Ireland, Lord Denning said that automatism covered situations where the defendant was acting without any control of the mind, such as a spasm, such as a reflex action. So automatism looks a bit like the word automatic. We're looking for automatic actions from the defendant. It's an important principle of criminal law, of course, that the actus reus must be voluntary. We know that from one of the very first cases we studied, Hill and Baxter. So the fact that if you're having a spasm, reflex action, your actus reus is not going to be voluntary. So that's the rationale, if you like, for having the defence at all. In order to succeed with it, there are two requirements. The actions must be completely involuntary and the cause must be external. Considering this completely involuntary to begin with, Attorney General's reference number 2, in that particular case, it was said that there had to be a complete destruction of voluntary control. So in that case where the driver was driving without awareness, he still had some control, so therefore wasn't able to plead automatism. Whilst that seems fair enough, Clarkson and Redding have critiqued this area and said that this is problematic because psychiatrists believe that even when unconscious, people can act voluntarily to a degree. So again, it's not a particularly clear defence in that respect. The second requirement for automatism is that the cause of the automatism must be external. So in RT, in that particular case, we said that extreme stress on the defendant could be an external cause. And in R quick, nice classic example of this here, taking drugs, be they legal or illegal, that would be an external cause because taking the drug, it's an outside cause, you're bringing it into the body, it's external, so that would be automatism. And it's this requirement for an external cause for automatism which has led to the law becoming illogical, incoherent. If we scroll back up here to remind ourselves, it's the internal-external distinction. And if you think about that, if a diabetic doesn't take their drugs, that's an internal cause, insanity. If a diabetic does take their drugs, that's an external cause, automatism. And of course, that's completely illogical because it's the same disease that has led to the defendant doing something, but the defence is different. That's illogical, that's unfair. And that's really the point that I'm making here. So I've put that bit that I've just explained. If he's acting due to a diabetic state through failing to take medication, that's going to be insanity, Hennessy. But if he takes it, it's external and it will be automatism, quick. Equally, that same problem would apply with sleepwalking. If sleepwalking is due to an internal sleep disorder, this would be insanity, Burgess. But if, for example, the defendant had been hit on the head by a stone, that would be an external cause. If that bump on the head caused them to sleepwalk, then it would be external, it would be automatism. This goes completely against common sense. This is my AO2 point here. Seems very unfair on the defendant. I've got a quote here from Lawton, LJ, in the case of Quick actually. Lawton said that automatism is a quagmire, seldom entered nowadays, save by those in desperate need of a quick defence. So he's pointing out that it's a very problematic defence, which of course is what the question is asking you. Final rule on automatism is that it must not be self-induced, and you've got Bailey on that. But then if you remind yourselves of the case of Hardy, it seems really unfair. In the case of Hardy, the defendant had taken his girlfriend's drugs, and arguably it's reckless to take someone else's drugs, but because they had the opposite effect to what he expected, he was allowed the defence. It wasn't self-induced. This is strange, conflicts with the case of Bailey. So I'm wrapping it up now in my conclusion that it's clear that the law on insanity and automatism is unsatisfactory. The distinction between internal and external causes is the big problem. That should definitely be abolished. The defence of insanity should be reformed. It's bonkers that we're still using a case from the 1800s. We need to bring it in line with current medical thinking. The Law Commission has recommended a new legal test for determining whether a person's unfit to plead. And I'm sort of ending there by saying that those proposals would be an improvement to the law. And as usual, your mark band grid with your AO1, AO2 at the end.